The first optional protocol to the International Covenant on Civil and Political Rights is an international treaty that establishes an individual complaint mechanism for the ICCPR. It was adopted by the UN General Assembly on December 1966 and came into effect on March 23, 1967. The protocol allows individuals to send written communications to the United Nations Human Rights Committee alleging violations of their rights under the International Covenant on Civil and Political Rights. After considering the complaints, the Human Rights Committee then notifies the appropriate party, who has 6 months to respond after receiving the notification. Parties acknowledge that the HRC has the authority to hear complaints from people who feel their rights under the Covenant has been infringed. This suggests a duty to facilitate access to the committee and to stop any reprisal against complainants. The HRC has jurisdiction to receive, consider, and hear communications from individuals claiming to be victims of human rights violations, as well as the very several procedural hurdles to jump before the committee can find a case admissible. There must be an identified victim claiming a violation of a specific right protected by the ICCPR. All available domestic remedies must have been exhausted prior to the complaint. The impact of the optional protocol to its member states: it enhances the protection of human rights by providing a mechanism for individuals to seek redress for violations of their rights under the ICCPR. This helps to ensure that state parties comply with their obligations under the treaty. By allowing individuals to file complaints and get responses from the HRC, the protocol holds state parties responsible for their actions. This encourages accountability and transparency in the application of human rights. The protocol's complaint mechanism has led to the development of jurisprudence, which provides guidance for states and individuals on the interpretation and implementation of the ICCPR. This, in turn, helps to clarify the meaning of the obligations under the treaty. The protocol reinforces the obligations of state parties to protect and preserve basic human rights as outlined in the ICCPR. This includes the duty to provide an effective remedy for violations. To first tackle the question, we must establish what a reservation is. A reservation is a unilateral statement made by a state or international organization when signing, ratifying, acceding, or otherwise expressing its consent to be bound by an international agreement, whereby it purports to exclude or to modify the legal effect of certain provisions of the international agreement or treaty in their application to that state or international organization. A state or international organization may want to participate in an international agreement or treaty, but maintain its position on important issues that it feels are counter to its interests. They may not want to commit to specific procedural requirements, like mandatory dispute resolution in accordance with the compromissory clause. They may also wish to assure that its treaty obligations are compatible with peculiarities of its local law. These are the reasons that could motivate a state or an international organization to interpose a reservation when it expressed its consent to be bound by a treaty. The Vienna Convention on the Law of Treaties contains in Articles 19 to 23 a system of rules on reservations to treaties. Whether they can add a reservation to Article 1, the State Prime Minister of Mandalore should consider the fact that on 23rd October 1997, the government of Jamaica became the first country to withdraw from the first optional protocol to the International Covenant on Civil and Political Rights. Not long after Jamaica's withdrawal, Trinidad and Tobago immediately reacceded to the first optional protocol, adding a reservation that eliminated the right of appeal for prisoners on death row. These governments maintained that their actions were intended to allow their criminal justice systems to efficiently carry out the executions of prisoners who were overcrowding the death row in these countries. Not because they had a weaker commitment to upholding human rights, but they believed that they were doing what was right for their state. In doing so, these respective governments stripped their citizens of an important protection against human rights abuse. The idea of making reservations to multilateral human rights treaties, as stated by Jose Maria Ruda, raises one of the most controversial subjects in contemporary international law, because it is an area where individual state sovereignty collides with efforts to build one world public order. The United Nations Human Rights Council concluded that the relevant standard for assessing reservations under the ICCPR and the first optional protocol is to ask whether the reservation is compatible with the object and purpose of the treaty. Article 19, subsection C of the Vienna Convention on the Law of Treaties provides that states may make reservations unless, as stated under subsection A, the reservation is prohibited by the treaty. Also stated under subsection B, the treaty provides that only specified reservations which do not include the reservation in question may be made, or under subsection C, the reservation is incompatible with the object and purpose of the treaty. Although the Vienna Convention entered into force after the ICCPR, the committee noted that its terms reflect the general international law on this matter, as had already been confirmed by the International Court of Justice in the reservations to the Genocide Convention case of 1954. The UNHRC in Kennedy and Trinidad and Tobago concluded that Trinidad and Tobago's reservation to the first optional protocol was contrary to the object and purpose of the protocol, rendering it invalid. Under the flexible reservations regime elaborated by the International Court of Justice in the reservations to the Genocide Convention case, also codified in the Vienna Convention on the Law of Treaties, the inquiry should begin by looking at the text of the first optional protocol. The treaty neither prohibits reservations nor permits any specific category of reservations. Under the ICJ's opinion and the plain reading of the Vienna Convention, the compatibility test should be applied, deciding whether the reservation is contrary to the object and purpose of the protocol. There is no doubt that reservations to human rights treaties are incompatible with the fundamental notion of human rights as being of universal application to every human being. Extensive and undefined reservations are of no help to the treaty bodies and are incompatible with the object and purpose of the Human Rights Treaty. According to Article 19 of the Vienna Convention, reservations of a treaty can be introduced throughout the different stages of entering into the treaty, but not after the state has become an official contracting party. If the state of Mandalore becomes a party to the ICCPR and its first optional protocol, it will be bound by the protocol's provisions, including the individual complaint mechanism. Mandalore cannot enter a reservation to Article 1 after acceptance, and any attempt to do so could undermine the treaty's purpose and the protection of human rights. It is also important for the state of Mandalore to know that the Article 1 of the ICCPR is a fundamental provision that sets out the scope and purpose of the treaty. It states that all people shall have the right of self-determination. By virtue of that, they freely determine their political status and freely pursue their economic, social, and cultural development. Entering a reservation to Article 1 would undermine the very purpose of the ICCPR and the optional protocol, which is to protect and promote human rights. In conclusion, I would advise Mandalore not to enter a reservation to the first optional protocol, as they would be undermining the rights of the people who are part of their state, and it would not be acting in accordance with the law on human rights treaties.